find it talking about racial equality is in the 14th Amendment Equal Protection Clause, and that's what I want to talk to you a little bit about, and about the way the Supreme Court has viewed the Equal Protection Clause, to kind of give the context for some of the things that we've been talking about today. So, I think I can say very briefly how we got to the 14th Amendment, and I'm going to ask your help in doing this. So, you remember that we had a Civil War, right? We had a Civil War over the issue of slavery. And when the North won that war, the country adopted an amendment to the Constitution that they thought would solve the slavery problem. Somebody remind me what that was? The number? It starts with the 13th. Good, awesome. Yeah, 13th Amendment, which bans slavery or involuntary servitude. Good, yes, good call. Good. Okay, so 13th Amendment bans slavery or involuntary servitude anywhere, everywhere. Remember, earlier we talked about how the First Amendment applies to government. Congress shall make no law. Not so the 13th Amendment. The 13th Amendment applies to everybody. And that makes good sense, right? Because slavery is both a state institution but also a private institution. So we thought, we'll enact the 13th Amendment and we'll do away with slavery. But that didn't really solve the problem, did it? Does anybody know what happened instead of slavery?
Mass incarceration.
Mass incarceration was part of it, much later.
You need to be up here.
Oh, I'm sorry. Okay. What else? Yeah. The black codes, good. Tell me a little bit about the black codes.
The black codes were essentially pieces of racist legislation that were employed in the South as a means of delegitimizing black ownership of land and property, as well as creating inequitable restrictions on public facilities.
Okay, good. So the black codes did a lot of different things, right? They prohibited freed blacks from owning property, from entering into contracts, from going to court to sue or to be sued, from voting. Yeah.
Also sharecropping.
Sharecropping, right? And that was also a function of the black codes. Of course, you were a sharecropper because you couldn't own property. Good. Were you going to add something?
I was going to say the same thing.
Yeah, okay, excellent, good, yep.
And then
Federal troops were removed from the South. Okay, that's right. I want to focus for a minute on the black codes and the sort of condition of de facto slavery that they kept freed blacks in. At that point, the country said, you know what, we've got a different problem to solve. It's not a slavery problem anymore, but it's very closely related. And what we're going to do is enact the 14th Amendment. How did the 14th Amendment address some of these issues? What are some of the provisions in the 14th Amendment that would have addressed some of these issues? You can look at the 14th Amendment if you like. Yeah.
There was the due process clause.
Okay.
Amendment, which means that equal protection or equal access to due process is guaranteed through the states.
Okay, due process clause.
That state clause.
Good, and well, you give me a mouthful, right? But if we just take the due process clause on its plain terms, you can't deny due process. You can't deny life, liberty, or property without due process of law. What else is in the 14th Amendment? There is other stuff, and I know some of you are reading it. Yes? I'm sorry? The Equal Protection Clause. Okay, good. So we have due process. We have equal protection. What else? There's another big one in Section 1 of the 14th Amendment. Yeah. Citizenship clause. Good. And one more. You're right to skip by it because the Supreme Court has basically written it out of the Constitution, but it's nevertheless there in your text. So what is it? Starts with privileges. It really ought to be in this version of the Constitution. Privileges and immunities. Do you see that language in the 14th Amendment? What does that mean? Can anybody help me with that? Privileges and immunities basically means fundamental rights. And at the time of the framing of the 14th Amendment, it could have meant a whole mess of different things. We don't really know because the Supreme Court early on basically wrote it out of the Constitution in a case called the Slaughterhouse Cases. I'll put it on the board, we're not going to focus on it, privileges and immunities. We see that language in other portions of the Constitution as well. Now, the 14th Amendment didn't solve the problem either, and the reason why is because clever states figured out ways to disenfranchise freed blacks and black people in general through different devices to prohibit them from voting. How did states do this? Do you know? Yeah.
There were
Literacy tests. Literacy tests applied in a way that magically blacks would never pass, but all whites would. Poll taxes. What's a poll tax?
You have to pay a tax to vote.
You have to pay a tax to vote, which means that poor black people can't, right? And poor white people, well, they kind of get a pass. Okay, good. What other ways? Yeah.
Like the
Grandfather clause. Excellent. What's that?
It's if your grandfather could vote, then you can vote, but if your grandfather couldn't vote,
Right. And what's the problem for freed slaves?
then their
Their grandfathers couldn't vote, right? Okay, good. Yeah. Whites only primaries, we saw those much later. That's right. That was a more recently devised device to disenfranchise black people. And things like voter ID, restricting times and days of voting and the like, those are other ways that we see this happen today. That's exactly right. In response to all of these things, we enacted the 15th Amendment, which bans racial discrimination in the vote. And we thought that would solve the problem too. Of course, we discovered that it didn't fully solve the problem. And we're still working on the problem today, aren't we? Well, what I want to focus on is one piece of the 14th Amendment right now, equal protection. And I want to talk about different ideas of equal protection, moving us from Plessy versus Ferguson to Brown versus Board of Education to the way the court's dealing with equal protection today. So let's start with some definitions. Equal protection. What is it? You know what? I think I have something in my bag that's going to help us out with this. I need 2 volunteers. Can I get 2 volunteers? Okay, 1, 2. Yeah, why don't you come on up to the front, please? All right. It's always good to have candy, isn't it, at presentations? So that's what I brought, some candy. Do you guys like Hershey bars?
I'm vegan.
Oh, you're kidding. Really?
Yeah.
All right, let's pretend you're not vegan for a minute. You'd like Hershey if you weren't vegan, right?
Sure.
Maybe. You would. All right. Okay, I'm going to do, so you can turn around. Let's introduce yourselves to everybody if they don't know you already.
Hi, I'm Bria. I'm going to eat for
Okay?
Hi, I'm Ashley. I go to John Mason High School.
All right, awesome. Thank you guys for volunteering. We really appreciate it. Hold up your hands for a second. You can see that neither of our volunteers has a candy bar in their hands, right? And as it turns out, I have 2 candy bars here. So what do you think would be an equitable distribution of my candy bars? Yeah?
Each of them will get 1.
Each gets 1. Okay, let's try that. Each gets 1. Right. Okay, so I treated them equally, right? Equal treatment with an equal result. They now each have 1 candy bar.
But let's say 3 and a half.
Hold on. Hold on. Hold on. Okay, so one notion of equality, let's call this notion, well, let's call it notion 1, is equal treatment, equal outcome. Right? Okay, let's have those candy bars back. All right, now we're going to start 1 candy bar, right? Hold up your hands. We see the one volunteer has 1 candy bar, the other has none, right? Now, we just said equal treatment, so let's apply that principle now. I'm going to treat them equally and distribute a candy bar to each. Candy bar, right? Keep your hands high. Equal outcome? I ask you. No, right? 2 candy bars versus 1, that's not equal at all. So what we've got is a notion of equality that says equal treatment, but not equal outcome, right? Equal treatment, but not equal outcome. Are you guys talking about candy bars or fingernails? Okay, so we've got not equal treatment and not equal outcome. Now, if we start 1 volunteer with 1 candy bar, the way to achieve equality, right, I think is quite obvious, is to give 2 candy bars to 1 volunteer, but 1 candy bar to the other. Now, what we've done is we've treated them differently, but if you hold up the candy bars, the outcome is equal, isn't that right? Different treatment, equal outcome. Why don't we call that another version of equality, or another way that we might look at equality? Different treatment, equal outcome. All right? Candy bars back, please. You're both going to start with 0 candy bars this time, and I'm going to have the same distribution, different treatment, 2 candy bars versus 1, but, hold up the candy bars, different outcome, right? Crazy. Isn't that weird how it works? Okay. Different treatment, different outcome. I've got one more for you. Candy bars back. All right, you ready for this one? I'm going to throw you a real problem. One candy bar to each, but are they equal?
No.
By one reckoning, they're not. Does anybody want to make an argument that they are?
They're both candy bars.
What if we have one volunteer who prefers Twix and another who prefers Hershey's? There we go, right? Okay, so you've got disparate treatment or different treatment, and then kind of a question mark here, right? What kind of outcome? We don't know. Maybe it depends on their preferences. So let's thank our volunteers for this. You guys can have some additional candy bars, and I'm going to leave it to you to distribute them among the two of you or your friends equitably, okay? You can decide what equal protection means. But what I want to do is riff on this for a second.
I'll give them to sister. She'll love you more.
Awesome. That's a great solution. Give them to your sister. We should write that down as number 6, right? Different treatment and give to sister. Okay. Now, you guys can go ahead and have a seat. Thank you very much. You all know Plessy versus Ferguson, yeah?
Yeah.
What's going on in Plessy? What's the rule? Yeah, okay. Say a little bit more. Yeah.
It means that you can keep 2 races separate, like separate their public facilities that they can have access to, where they can sit on like a bus or a train.
Yep.
And as long as they both get equal treatment, as long as they're both able to access the bus or both able to have access to the water fountains,
Yep.
it's not a violation of the 14th Amendment protection clause to be separate.
Equal facilities, simply separate, and the Supreme Court says that's equality for the purpose of the Equal Protection Clause.
Yes.
You understand? Which definition of equality does that kind of assume of the 5 that we have on the board?
Equal treatment, not equal.
Well, Plessy doesn't assume that because Plessy says that equal treatment equals equal outcome. So which one comports with Plessy? Number 3, different treatment, equal outcome. Okay, maybe. Anybody want to make a case for 1? Maybe for 5. Okay. Okay, different treatment, equal outcome. Maybe. Remember, though, it's important in Plessy that the rail cars are perfectly equal. Now, we know that's a fiction, but let's go with it for a second. The rail cars are perfectly equal. So the only discrimination in the case is sending black people to black cars, white people to white cars. Otherwise, they're perfectly equal, and the Supreme Court says that that equals equality. You might say that we're at 3, you might say that we're at 5, you might even say that we're at 1. Let's see if we can draw this. What you've got is kind of equal treatment on the treatment side, right? And we're going to put that equal treatment through the rail cars. And on the outcome side, you have equal outcome. And the Supreme Court says, what's the problem? There's no problem. All we've done is put black people in black cars, white people in white cars, made the cars perfectly equal. Equal treatment leads to equal outcome. You see? That's what's going on in Plessy. Now, we all know that that was a fiction. And the litigators in Brown versus Board of Education knew that was a fiction. So they wanted to take down Plessy versus Ferguson. But this was an extraordinarily hard thing for them to do. We had racially segregated schools, right? That was easy. But to find equal school facilities that were segregated turned out to be very, very hard. What it meant was they had to find a segregated school system where the facilities were actually equal so that they could take down this equal treatment, equal outcome result in Plessy versus Ferguson. It would have been easy for them to say that segregated schools are unconstitutional if the facilities were dramatically unequal, as most of them were. Much harder to say that Plessy goes down, right, by finding equal facilities that are also segregated. So the attorney spent decades doing this, scouring the country, looking for school districts that had sort of facial measures of equality in terms of the facilities, the teacher-student ratio, the books, the desks, that kind of thing, doing the best they could to find schools that were separate but equal so that they could pitch the argument that separate is inherently equal under Brown versus Board of Education. And so they found some of these districts, right, where black kids go to black schools, white kids go to white schools, but the black schools and the white schools are more or less equal, at least more or less, to allow them to take on Plessy versus Ferguson. And then they measured the inequality in the results using social science. Does anybody know how they did this, some of the tests that they used in Brown versus Board of Education to show that equal treatment leads to an unequal result? Have you learned about these or read these? Does anybody know the Dawes test, for example? Yeah? So somebody who knows about it, you want to tell us a little bit about it?
Well, the Dawes test I'm thinking of, I might be incorrect with this, is like you put two dolls in front of a child, and one doll is black, one doll is white, and you ask them a series of questions. There was actually a video of it. It was done in Italy, I think. You may ask which one is black, which one is white, but then you get into questions like which one is beautiful, which one is nice, which one is smarter, and then
Which ones do you want to be friends with?
And
Which one do
then-
you want to play with?
Yeah.
Which
And
one is the
then-
evil one, right?
Yeah.
And
then
what did
after
they
that,
find?
you ask- And they find that a lot of times, black doll is the one that gets the negative answers. And I know that.
Wait. By which kids, black or white?
Oh,
Well, by black kids. Black kids identifying the black doll as the evil doll or the bad doll. The white doll is the one that they want to play with, right?
and at the end, we usually ask which one looks like you.
Which one look, yeah, unbelievable, right? And so they use that kind of social science evidence to show that even with these facial measures of equality in these segregated schools, you're getting a different outcome, an unequal outcome. Yeah.
I was gonna say, like, I think a contributory reason to that is the representation in the media or in pop culture. Often in like TV shows or movies, the protagonist is usually white, unless there's a specific context to the story that makes the protagonist African American.
Okay, but remember, in 1954, black kids in the South aren't spending a lot of time watching TV, right? So where are they getting the message that black is inferior to white? From everything else, right? That's the point in Brown versus Board of Education, that you can treat kids equally by the reckoning of Plessy versus Ferguson. Again, we kind of know that's a fiction, but that's the fiction the court gave us, not one that we made up. So we've got equal treatment, but Brown shows us that we get an inherently unequal outcome. Now the question is why? Well, why? Something must be going on in here, right, to produce that unequal outcome. Before I said that those are the trains in Plessy versus Ferguson, maybe they're the schools in Brown versus Board of Education, or maybe it's society, right, in general, which is I think what you're saying, that we get all these kinds of social messages in the way that we structure our lives in American society, particularly pre-1954, that some form of societal racism or societal inequalities is going to lead to this unequal treatment or unequal outcome on the outcome side, right? So what they were able to show is that equal treatment, in fact, leads to an unequal outcome. Now, if this is the story of Brown versus Board of Education, which measure of equality or which definition of equality does it line up best with? What's the story of Brown 2, right? Okay, now notice a second. From Plessy versus Ferguson, we were talking about 1, 3, or 5. Now we've gone to a completely different notion of what equality means. We've gone from this idea of concern on the treatment end to concern on the outcome side, right? Before in Plessy versus Ferguson, we said equal treatment. Well, that's really what we're concerned about. As long as people are treated equally, the outcome will be equal, and that satisfies equal protection. In Brown, the recognition that outcome matters and a focus on disparate outcome. We've really moved to number 2 with a concern about equal outcome, 1954, right? Do you see that? Okay. Does anybody know what happened after Brown versus Board of Education? Did the schools magically desegregate? No. Oh, good answer. Good for you, right? It required Brown 2, with all deliberate speed, empowering the lower federal courts to order desegregation in particular cases. And a lot of these cases went up to the Supreme Court. Over time, what the Supreme Court said was, when school districts have segregated in law, or what we call de jure, then the district courts can order a race-based remedy to that segregation, right? In other words, if the treatment was unequal in the beginning, then the district court can address the unequal treatment with a race-based remedy. But if the treatment was equal and the schools were still segregated, this was largely the story in the North, where you had segregated schools, not by law, because the law didn't segregate the schools, but things like housing patterns, right, segregated the schools. We live in a society where many of our schools are based on geography. We're assigned to our local public schools, and as it turns out, in many or even most areas of the country, we sort ourselves out by race in the way that we live, right? And so therefore, it's not surprising that those patterns of residential segregation are replicated in the school system, even if they're not ordered by the state. We call that de facto segregation. What we saw in de facto segregation is about exactly what we saw in Brown versus Board of Education. The fiction that everybody's treated equally, but because of something that's going on in this box, like patterns of residential segregation, we get a segregated or unequal outcome. And what the Supreme Court has said over the Brown 2 decisions is, you can't remedy that problem with race-based remedies. You can't do anything about that problem. Now, over the course of these decisions and a whole bunch of subsequent decisions that we could talk about if we had a little bit more time, what the Supreme Court has done is kind of creeped slowly back from this concern about equality, equal outcome, back to the concern about equal treatment on the treatment side in the first place, right? In a way, creeping us back toward Plessy versus Ferguson. In other words, what the court has said is, look, unless you can show that there was illegal discrimination in the first place, right, a concern about the treatment side, we're not concerned about unequal outcome. That's not a constitutional problem, unless there was unequal treatment in the first place. We've kind of come full circle to Plessy versus Ferguson, even though Brown is still good law. Yeah?
I was thinking about like affirmative action and how that kind of goes into number 3 with different treatment, equal action,
Yep.
Equal outcome, and like affirmative actions like that with housing, certain scholarship for people of color and other minorities, disparages in housing and stuff. And I kind of like I was getting what you were saying. You were saying we're kind of going back to equal treatment. And
Say more why. Why use affirmative action? Tell me why you see affirmative action as kind of a return to a Plessy versus Ferguson kind of world as opposed to Brown.
My idea is more at first, affirmative action I thought was good because when we think about societal racism and systematic racism, you can't treat them equally because one group is remained unaffected by it, while another has remained greatly affected by it. So you
Affirmative
have to
action is
treat them-
like number 3, is what
Yeah.
you're saying.
You have to treat them differently in order to have an equal outcome. But then we started to ignore it, and we started to get into like white people being affected with the different treatment and not being favored for certain universities. And that's
Yes.
how we got back to equal treatment without receiving equal outcome.
Awesome analysis. And basically, I think what you're telling me is that affirmative action, or at least remedial affirmative action, looks a lot like number 3, where you treat people differently in order to achieve an equal outcome, and we call that equality, right? Well, if we call that equality, what we're concerned about is equality on the outcome side, over here, right? That's what we would be concerned about, if indeed that's what we were concerned about. But we've seen the affirmative action jurisprudence kind of slowly creep back to a concern, not about equal outcome, but as you said, about equal treatment in the first place. And people complaining about one race not being treated equally on the input side.
And then there is not equal outcome. That is,
Yes.
the group that was disparaged against is once again in the same position.
Good. And so I think that's an excellent example. That's an excellent example. Again, kind of coming full circle to the notion of equality that we had under Plessy versus Ferguson, even under the guise of Brown versus Board of Education. Now, the Supreme Court's most recent say-so on this was actually in a desegregation case not too long ago. When Chief Justice Roberts was on the court, he wrote the opinion. And he wrote some language in the opinion that I think underscores exactly what we're talking about in the Supreme Court's view on race today. What he said is, the way to stop discrimination by race is to stop discriminating by race, right? It's definitional, it sounds really good, but it's a perfect statement of concern about equality on the treatment side and not on the outcome side. Now, if everything that I'm telling you is true, right, that we basically have Brown versus Board of Education on the books, but that we've taken Brown and kind of returned full circle to a view of equality that actually comports with Plessy versus Ferguson, what are the implications of that? Do we care? Do we care that we've returned to a notion of equality under the Equal Protection Clause that aligns with Plessy versus Ferguson? A concern on the treatment side, not the outcome side. What do you think of our notions of equality on the board as a starting point? What do you think, where do you think we start? Are we equal as a starting point, or are we different as a starting point? Does everybody in our society have one candy bar, or do some have one and some have 0?
Some have 0.
Yeah, some have 0. Okay, so we're on one of these models, right, where we've got different treatment, so that gives us a choice. If we're different, we can treat people differently and achieve equal outcomes, or we can treat people differently and we can get different outcomes, right? Or treat people differently and get indeterminate outcomes depending on their needs and capabilities and whatnot. So what? What do you think we ought to be doing? Different treatment, equal outcome, you think?
Yeah.
That's what a lot of people think. Some people want to make a case for equal treatment. Say more.
I don't think so. We should treat people differently.
You shouldn't treat people differently. Treat them exactly the same, even if it results in an unequal outcome. Yeah?
Yeah, I respectfully disagree with that, because if we return to the Plessy versus Ferguson, my mindset of thinking that it was catastrophic, like civil rights, welfare implications. And so it's okay for treatment to be unequal as long as the outcome is equitable.
Okay.
Quality outcome.
So we're not concerned about equal treatment on the input side. We could treat people unequally so long as we get an equal equality on the outcome side. Yeah?
I think it's dicey territory when you start talking about what is equal outcome, because in any human society, no matter how equitable it is, there will be no such thing as unequal outcomes unless it's mandated by the government. So I view that as dangerous.
Mm-hmm.
So my personal belief is that everyone is treated the exact same in terms of things like affirmative action. It needs to be merit-based, not race-based, because we're supposed to get where we want to go based on our personal talents and personal abilities, and not through the discriminatory lens of race.
Good. Okay. And so what you're saying is we ought to be concerned about treating people equally on the input side, right? Even if in some cases that leads to an unequal outcome.
It will always happen. There will always be an unequal
it will always be an unequal outcome, because maybe what's going on here is not just societal racism, but also things like people's talents and abilities and time and skill and effort and whatnot.
And individual
Okay,
preference.
and individual, okay, good, and that's inspired a lot of hands. Yeah,
I think that taking analogy only works if you have an equal base. So if the starting point is the same, and if you have people treated in one equal
Good.
outcome, that is okay. However, with the initial unequal society, then you have to have an equitable.
is that true?
That everyone needs to be starting at the same base?
Yes. Does your theory assume that everybody's starting at the same base?
Yes.
Good. So now I think we've drilled down to really find out what the meat of this argument is about, right? Do we start off on an equal base, or do we start off differently? Your notion of where we start may help answer your question about which you prioritize, equal treatment or equal outcome. Okay, a lot more questions. We'll get to as many as we can. Yep.
I think you can kind of compare this analogy to like the colorblind kind of idea, where we think, oh, like just because we don't like the easy way to solve discrimination is not to see color, but you need to acknowledge that there's differences. You just need to learn how to respect them.
Why?
Because if you ignore that there are differences between different people, you don't acknowledge that some people have different preferences and different history that requires a different treatment.
Or even the facts of difference in general, right? Okay, good, nice. Yep.
I think it's more of like we're all kind of different, and if you think of it like in a criminal sort of way, let's say somebody commits a crime, and let's say they are mentally ill.
Mhm.
You wouldn't just treat them like somebody who's mentally unstable. You wouldn't like throw them in a jail. You would have to take them into like a facility, and so that they could get treated. But if you say are not mentally ill and you know what you did was wrong, I guess, then you would like go to jail.
Okay, good. I like the way you've taken race out of it to talk about a different characteristic that also represents difference, to illustrate that in order to achieve an equal outcome, sometimes you have to treat people differently, using a different example. That also, well, okay, so that's really interesting, because then the question becomes, is race like, in your example, mental disability, right? Are those two alike in the sense that people of different races are differently situated from the get-go in our society, right? And that really cuts to the core of the question. Again, depending on how you view that initial starting point, that will often tell you whether you're concerned about equal treatment versus equal outcome. Yeah.
Prejudice has been present in society since humanity started. So
Mhm.
I think that it's a complete waste of time, energy, thought, and resources to act as though we all start out as equal because people don't. So instead, let's just try to create a situation where we are all equal, and then we can work from there, and then sort of be in a situation where we can treat everyone equally with equal out.
Excellent comment, but do you understand that your premise is the contested premise? That's the very contested premise. Now, part of what I do in my day job is South African constitutionalism, and the South Africans have dealt with this in a really interesting way. They have overtly adopted a disparate treatment regime in order to achieve an unequal outcome. And I would posit that part of the reason that they've done that, and that they can do that successfully, is because apartheid is so recently in their history and consciousness, right? Whereas slavery, even the civil rights movement, seems distant to many of us in our society. And we kind of feel like we've gotten over racial problems. In fact, I think in some ways that's at the heart of Chief Justice Roberts. The way to stop discrimination by race is to stop discriminating by race. In order to make a claim like that, I think you have to assume that we've basically overcome our racial problems. Okay, so I know we've got great comments. We could go all afternoon on any of these topics, but let me just, I'm sure Dee's got some closing comments, but you guys are so sharp and so on the ball, and I hope you'll all come to law school. I hope you'll come to John Marshall Law School and my classes, because you're doing an awesome job. So just keep it up. Thank you.